common question for people who are under investigation but haven't been charged yet. They might see a combination of state and federal law enforcement involved in the investigation. And that is, what's the difference between state charges and criminal charges in federal court? Okay, state versus federal court, what am I looking at? There are some significant draconian penalties that will be imposed in the federal system. Some really onerous mandatory minimum penalties that will apply in certain types of cases. Let me give you some examples for both state and federal. Aggravated drug trafficking on the state side. It's a Class A offense. Mandatory minimum penalty, 4 years. If you've got a trafficking charge based on a certain amount of weight or a prior conviction for a drug offense in federal court, you're now facing a 10-year mandatory minimum. All right, and the only way to get out from underneath that is with the government putting a motion in under Rule 5K1 to reduce or allow you to get out from underneath that mandatory minimum. Also, there are things called the guidelines or the guideline rules as they apply in federal court that dictate where you should fall within a certain category of crime based on criminal history and severity of the crime. There's a lot more that goes into an analysis of a federal case, what your liability is. Here's another really great example to show the stark difference between a state and a federal case. Okay, it could be the same crime. You are looking for a prostitute online. You come across an advertisement. You decide that you're going to go there and learn that this person is under the age of 18. And you say, that works for me. That's what I'm looking for. You go to knock on the door. You give the money over, you're tackled by the police. On the state side, there's no mandatory minimum. You could be looking at significant time. You could be looking at months or maybe a year or so, maybe longer, just depending on your history. You're talking in general terms here. On the federal side, you haven't even consummated the act. You didn't have sex with this person, this theoretical under the age child. You just attempted to get there. Just that attempt alone is a 10-year mandatory minimum penalty, up to life, for sex trafficking. Engaging with someone that you expect was under the age of 18, that you didn't even actually touch or have sex with. So look at the stark differences between federal and state. In general, the penalties on the federal side are significantly worse than the penalties you might be facing on the state side. It's always in your best interest if this case is prosecuted on the state and not federal side. So what makes an offense a federal crime versus a state crime? Well, I mean, there's statutory reasons for certain crimes being federal, but what gives the federal government the power to charge you comes under the Commerce Clause. So if the crime or the commission of the crime involves interstate commerce, the feds can choose to take the case. And yes, you could be charged in both state and federal court, and that is not double jeopardy, just in case you're wondering. So here's a classic example. You're going across to Massachusetts and you're bringing drugs into Maine to sell. All right. The feds could choose to pick that case up if they want to. If it's a small case, they probably won't. But if you're moving a large amount of weight and there are potentially a lot of co-defendants that they can get to roll and cooperate, you might find yourself charged. Why? Because bringing those drugs in across state lines, can involve interstate commerce. Under the Commerce Clause, anything that could theoretically be regulated by the government, that's commerce, that falls under the Commerce Clause, the federal government can get involved. So it could be a state trafficking case, and then the feds get involved, and you're now facing federal charges. And the state doesn't have to dismiss those charges. They can still prosecute you, and you're still prosecuted in federal court. So you could be facing charges on both sides of the equation. Now, in most cases, the state will ultimately drop the state charges, especially if you're going to be pleading out in federal court. But what allows the feds to bring charges is, does it fall under the Commerce Clause, is essentially how most of these charges happen. Same with sex trafficking case. The ad you found was on the internet. Well, that falls under the Commerce Clause. Okay, computers, internet, all of that falls under the Commerce Clause. So the feds can get involved in most cases that they choose to get involved with if it falls under the power of the Commerce Clause. If you're charged in federal court, and you want to know, is it easier to resolve your case federally with a federal prosecutor than it is with a state court prosecutor? The answer is not necessarily, probably more difficult, especially if you are facing mandatory minimums. When you're facing a mandatory minimum, you've got to cooperate with the government. If you don't cooperate with the government and you plead guilty, that mandatory minimum is going to apply. So on a crime that you might have faced 3 years on in state court, you could be facing 10 years in federal court. And it's really hard to negotiate with an opponent who holds all the cards. And usually when the feds get involved, they only get involved with cases that they are almost feel like a sure thing in order to obtain that conviction. So you have to have the government agree to work with you and cooperate. And they're only going to agree to entertain the idea of cooperation if you've got something to offer. If you don't have anything to offer from a perspective of cooperation, you don't have much to do or work with the government. And so that's really important to understand. On the state side, those relationships with the state prosecutors gain you, it's the coin of the realm. If you've got good relationships, while it doesn't guarantee you a specific outcome, it gives us a chance to negotiate something less than a mandatory minimum. Usually the prosecutor doesn't have to go to their boss to reduce this from a trafficking charge to a possession charge. But if the government's going to entertain a reduction of charges on the federal side, that's got to go right up the chain of command, and somebody higher up than that assistant USA prosecutor is going to have to make that decision. And generally they won't do it without cooperation in place. And if you're not willing to cooperate, then your choices are trial or a plea and try and reduce this to as close to the mandatory minimum as possible. If you've been charged federally, you need someone who's got some level of experience in federal court. Why is that? If the attorney's never been in federal court, they're going to be pretty shocked and blown away when they come to federal court. The rules are different than state court rules. Rules of procedure are different. Rules governing discovery are different. What the government has to turn over in federal court is different than what the government has to turn over in state court. This is the difference between being on planet Earth. Sky's blue, grass is green, I'm breathing air. Seems normal. But I've never been in federal court as a state defense attorney. And now is my first day in federal court. I feel like I'm on the moon. I don't have a helmet on. There's no oxygen. This is a completely different landscape and I'm unfamiliar with it. That's not the attorney you want in your case, where their first case is your case when it comes to federal court. And the federal system is very different. I mean, if you just look at how a federal courtroom is structured, the judge is way up high, away. Everything, the majesty, the power is all brought to bear in just how that courtroom is set up. And if you think it's intimidating for the attorney who's never been in front of a federal judge, imagine what it's like for you in that position with your attorney who's never been in front of a federal judge. So you want an attorney or a law firm that does have experience handling federal criminal cases. So you're under investigation. You received a target letter. Ultimately, you know you're going to be indicted and you're going to be brought before a magistrate. Or you might be charged and now you're being brought before a magistrate. Do I get bail? Is a common question. Well, in many cases, bail is almost automatic. There's a presumption that you have a right to bail based on the charge, period, in federal court. That presumption can be overcome, however, if the government files a motion for a detention hearing to detain you without bail because you are either a flight risk or a risk to the safety of the community. Certain charges automatically trigger a risk to the community that can't be ameliorated with traditional bail. Sex crimes involving children, for example, fall under the Adam Walsh Act. And what that means is if bail is going to be set, there must be electronic monitoring in place. And so in order to have bail set in your case, we need the following. We need probation to do an investigation, probation to make a recommendation, and then have a plan in place so that bail can then be an option for you. But if the government raises the argument for detainer that you're a threat to the safety of the community, or these charges are so serious and you have the resources that you're a flight risk, you could be detained without bail until your trial. So if you've been charged with a crime in federal court, you've received a target letter from the U.S. Attorney's Office, or you're being investigated and you think it might go federal, then you need to contact a law firm and an attorney with experience in handling federal matters. You need to call the Maine Criminal Defense Group today.